I will say this, if you're appearing via Zoom, please wait until your case is called and keep your microphone muted until so. And then that just makes it easier. If you're appearing in the courtroom here, if you want to wear a mask, wear a mask. If you don't want to wear a mask, don't wear a mask. I'm not going to make your health decision for you. It's not my job. And so with that, Mr. Weiner.
Yes, last page, Ralph.
Who is
Yeah,
it?
Stanley. I'm sorry, it goes by Clint. My bad. Forget his
Stanley.
legal name, Stanley.
Stanley Ralph. All right, this is cause number CR 21. Sir, you can step over here on the other side of your attorney. 6-392, the state of Texas versus Stanley Ralph, set for discovery status.
Yes, Your Honor. This is a case being handled by Ms. Pace, who's out. My understanding is there's
She
two.
appeared via Zoom yesterday. Is she not available via Zoom today?
I guess not today. Same, it would be the same announcement whether she's here or not. There's two outstanding documents, a SANE report, and then some notes from the Child Advocacy Center that have not been turned over yet.
How long? Can I see the docket sheet? Sorry. Again, I always wait till you start writing on it. So this is just the first.
It is. Yes, Your Honor.
Why don't I just reset it to August 4th for discovery status?
Great.
And does Mr. Ralph have conditions of bond?
I'm not
We
sure.
need to
either.
look and see. Sorry if I got that wet. My hand was on my coat over here. It's sweating.
Is that also in the afternoon on August 4th?
Yes, sir, 1:30.
Thanks.
All right, I'm going to put the standard sex offender conditions on him. And so we can get those. Do you have any other cases?
That's it.
All right, well, we'll wait. I'll tell you what. So what I'm going to do, Mr. Ralph, I'm going to set conditions on you that are standard in a case such as yours. Once I sign that and you go over that with your attorney, you'll be free to go and you have your reset notice. That way you don't have to wait around.
That'd be
or
great.
At least wait around for me again.
Thank you very much.
No. Yeah, hold Steve a long time ago. Making people work, so it's overwhelming. But, yes, sir. It's off the air. Yes, sir.
Murray Frank for discovery status.
Murray Frank.
He's incarcerated.
It's hot. Somebody must have turned that up to 74. I did during that Zoom meeting. It's freezing. All right, these are cause numbers CR 21-0329 and 0330-392 in both style of the state of Texas versus Murray Frank, and both set for discovery status.
Yes, Your Honor, we received.
Nothing missing that you would expect to have.
Nothing that I can
Okay.
tell now.
All right, well then, Mr. Frank, the court deems discovery status as held. Your next court date is August the 4th at 1:30 for pretrial. And so if you get out of jail between now and then, I need to see you on August 4th at 1:30 here in the courtroom.
And Your Honor, I had filed a motion to withdraw.
Okay, yes, and I have looked at that motion. Mr. Frank, do you have any objections to that?
No, sir.
All right, then granted. And then before you leave today, I'll have your new attorney for you.
Thank you, sir.
Sorry, that name didn't.
Further may I be excused?
Yes, ma'am. Mr. Frank, we'll let you know who your new attorney is before you leave out of here today. Can you get me so? Yes, sir. You know what page she's on? Here it is. Mr. Hawkins, correct. It's our initial. Yep. Amy Bookman. All right, this is cause number CR 21-0326-392, the state of Texas versus Amy Bookman, and set today for discovery status. State.
We have given an offer and all evidence to present counsel.
And I
picked up this just a few minutes ago, Judge. I didn't have that, but I have received the online discovery and I
Okay.
have received the offer.
Okay.
I've not gone with my client yet, but we have received it.
So you're not.
I have not gone with my client
Okay.
yet. I just received it a few days ago.
All right, well, then the court deems discovery status is held. Ms. Bookman, your next court date is August the 4th at 1:30. And can I see the indictment? And that'll be for pre-trial. All right, so we will see you back on August 4th at 1:30.
Thank you, Judge.
Mr. Scott.
Yes, Your Honor. Gregory Morrison for discovery status.
It seemed, anyway.
Gregory Morrison. Gregory Morrison. This is cause number CR 21-0354-392, the state of Texas versus Gregory Morrison. Is there a Gregory Morrison in the courtroom? I see no one, I hear no answer. There is not a Gregory Morrison appearing via Zoom.
No answer.
His name's been called 3 times in the lobby. There's no answer. The time is now 1:37. He was set to appear at 1:30. The court will entertain a motion.
Statement request bond forfeiture, Your Honor.
Granted, a capious issue, he'll be held with no bond, and I'm here all day. So it's fine.
Maybe excuse me.
Yes, sir.
Thank you.
Few hours away. Ms. Thompson. Matthew Poe. All right, these are calls numbers CR 21-0355 and 0356-392, both styled the state of Texas versus Matthew Poe, and both set for discovery status. And then I see a show cause here, so let's handle the discovery status first.
All discovery.
Your Honor, we are missing discovery in one of the cases that we requested, but what was sent to me was the same case I already had.
It's the companion.
Yeah, so I don't have all the discovery yet.
You don't?
I don't.
There's 2 offenses. There's 2 charges. They're from the same offense. So the discovery is the same. We'll just need to, I guess, duplicate.
I got you.
Okay.
All right, and then what's this show cause business?
It is here to have the defendant show cause as to why he violated the report on May 6th to show up. State will call 2 witnesses to testify.
Okay.
Ask this court to hold him in contempt.
Well, I'll tell you what we'll do is we'll, there's a motion to quash on file as well. So it looks like we're going to hear all of it. How long is this going to take?
30 minutes.
All right, let's do this. Let's, I'll recall it. If we can get to it today, we can. If not, do you think we're going to? Or do we need to reset it for another day? Okay, so we should be able to get to it. Let me handle all the non-contested stuff
Sure.
first, then we'll get back to it. The court does deem discovery status is held and sets pretrial for August the 4th at 1:30.
Yes, sir. Thank you.
Wait, I don't forget. I'm gonna have to recall it.
That's fine, Your Honor. You go second. I have one more case, Your Honor.
Okay.
Jonathan Arnold.
Jonathan Arnold.
And I believe he's on page 10, Your Honor.
Got it. All right, this is cause number CR 21-0370-392, the state of Texas versus Jonathan Arnold, and that is set for discovery status.
We have turned it over and made an offer, Your Honor.
Yes, Your Honor, on this case that's indicted, we do, but he also has a new case that's unindicted right now.
What's the new case?
I believe it's a possession.
PCS?
Yes.
I could have guessed it. All right, so Mr. Arnold, the court then deems discovery status is held. I'm going to order you to take a drug test today, though. You're going to go with probation and take the test, and when you get done, don't go anywhere. Come back in the courtroom, and we'll all go over the results together. All righty.
That's all I have ready, Your Honor, may I ask?
Yes, ma'am.
Thank you.
Mr. Harrison, yes, sir.
Page 3, top of the page, Brandon.
Brandon Collins. All right, this is cause number CR 21-0322-392, the state of Texas versus Brandon Collins, and set for discovery status.
Your Honor, there's a lot of discovery in this case. We provided everything we have at this point. We do believe there is some outstanding medicals on one of the victims that we have not provided.
Okay, but other than offense, alleged offense-related reports, all those have been provided from law enforcement.
Judge, I would agree with that. There is an autopsy that I think we're missing. I think that may be medical it's being referred to, but there's definitely an autopsy assessment. Additionally, there I had a question on the offense reports. Trooper Henry conducted multiple video interviews, but there's no report from Trooper Henry. I suspect there is one somewhere. So if the state could check on that, and will if there is provided.
Okay.
Additionally, there was a traffic stop that evening of the deceased. I don't know if there's any information from that, or do I know the state has it, but if there is, check on that.
Sure.
It's a collateral, but we'll prevent it.
I mean, I think the 3914 is pretty open. If it had any bearing on, I can't remember the exact language. I just read a case on it.
Pretty broad.
If it relates to just about anything in the case.
I think it's
Right.
really-
Right, and then the one other issue, during the interviews by Trooper Henry, one of the individuals interviewed was a Peyton Hanfield. She referenced that there might be video cameras from the neighborhood outside the Waterman House. If the state has those, or check on those. Appreciate that as well. And we've sent emails to follow additional on specifically what we're asking about.
Can I see the indictment? We have the indictment. Is this motor vehicle or watercraft? Okay. And in 3 counts? Okay, I don't need to see it then. All right, well then what I'm gonna do is I'm just gonna reset discovery status to August the 4th at 1:30. I'll give you an opportunity to reach out to DPS. Now, I don't know if they're sending the autopsy to that private company in Tyler to save money. Are they still doing that? It's not my decision. I just really wish they'd go through Swifts. You never have problems with Swifts. Anyway, okay, well, I'll reset it to August 4th at 1:30. All right, and Mr. Collins, does he have any conditions of bond?
He does, Your Honor.
All right, remember what those conditions of bond are. Make sure you abide by them, sir, and we'll see you back on August 4th.
Yes, sir.
All right,
That's all we have to reach.
yes, sir. Yes, sir.
Clayton Robinson, Your Honor, I believe it's page 5. Discovery status.
Clayton Robinson. All right, this is cause number CR 21-0318-392, the state of Texas versus Clayton Robinson, set for discovery status.
Everything in the state's possession has been provided. And that has been offered.
That's correct, Your Honor. We did just get the DVDs and CDs today, but we do have everything.
Okay. All right, then, sir, the court deems discovery status as held. Your next court date is August the 4th at 1:30 for pretrial. And so we will see you back on that day. Has he got conditions of bond on him?
I do.
I
Does he have? Has he got?
don't know.
Is there a protective order?
There is a protective order.
Okay.
Yes.
All right. Well, then, Mr. Robinson, make sure you abide by that. We'll see you in August.
Yes, Your Honor.
All right. Mr. Head.
Page 3 and 4, Jack Riskin.
Mr. Riskin, come on up. All right, these are cause numbers CR 21-0145 and 0146-392. The state of Texas versus Jack Riskin. And this is set for discovery status on each of these cases.
It's been provided normally, it has been called.
That's my understanding, Your Honor. I'm not aware of anything outstanding.
All right, well, Mr. Riskin, the court then deems discovery status as held. And your next court date is August the 4th at 1:30 for pretrial. And we need to see the docket sheet before we goes. All right, I'm going to order you to take a drug test today, Mr. Riskin. You'll go with probation. Take that test. When you get done, come back in the courtroom and we will go over the results together. Okay, sir? Yes, sir.
Commissioner Andrew Howard for Shelley Wiggins.
It's right here. Riggins. All right, this is cause number CR 21-0386-392, the state of Texas versus Shelley Riggins, and set for discovery status.
We're in the process of getting the information over. He wasn't set up in our portal yet.
Okay.
And we'll be making an offer sometime this week.
I believe that we're going to receive a couple of discs today. She's checking on the chart.
Okay. That's why we have the hearings, to make sure everything's good before
I
pretrial.
appreciate it very much.
And can I see the docket sheet?
Good to see you in person, Your Honor.
Yes, sir. Nice to see you. Nice to meet you. Did we ever get a result? I know I ordered her for a UA because we appeared on Zoom. I don't know if we got a result or not. All right, well, I'm gonna order her to take a drug test anyway. So, ma'am, you'll go take the test. When you get done, come back in the courtroom. We'll go over the results together. And your next court date will be September the 1st at 9 a.m. for a pretrial. Okay. You got this one on September 1. Is there a reason for that? Okay, that's good.
Yes,
So,
I looked on my calendar and you did reset it. Thank you all very much.
Yes, sir.
for doing that. We're on September 1. Yes, thank you.
Mr. Harrington. Frederico Jackson. This is cause number CR 19-0491-392, the state of Texas versus Frederico Jackson, and set for discovery status.
Discovery's been provided to the councils, including an offer.
Both, Your Honor, I'm not aware of anything outstanding.
Or why is this just now at discovery status on a 19 case? Do you know?
When I worked there, I think Discovery provided. on the house.
Can I see the indictment? I mean, not the indictment, the docket sheet. I'm sorry. I guess so. All right, well then, Mr. Jackson, the court deems discovery status is held. Your next court date, sir, is August the 4th at 1:30 for pretrial. And so just stay in touch with Mr. Harrington. Yes, sir. We'll see you in August.
Thank you.
Yes, sir.
Also, he's present.
Terry McCleskey. Who? All right, this is CR 21. Oh, that was on the other case. CR 21-0328-392, the state of Texas versus Terry McCleskey, set for discovery status.
Yes, Your Honor, my understanding is everything's been tendered. We just gave some additional DVDs. There's also an offer.
That's correct, Your Honor. I'm not aware of anything outstanding, and we did receive an offer.
All right, well, then the court deems discovery status as held and Mr. McCleskey, your next court date is August the 4th at 1:30 for pretrial. And I do need to see the docket sheet. All right, and sir, I'm going to order you to take a drug test today. You'll go with probation, take the test. When you get done, come back in the courtroom. We'll go over the results together. Who has the Smith County? Is that Smith County on board?
Good. Jeff Wood here.
Okay, are you representing, and who is it?
Tony McLean is her name, Judge.
Okay, if y'all don't mind, I'm going to do that one since Smith County's on board with us. All right, Ms. McLean, can you see and hear me okay?
Yes, sir.
And how about your attorney there in one of those boxes, Mr. Wood? You see him?
Yes, sir.
All right, and if I could get the state to move over so this camera right here can catch it. The state is right here. Can you see the state here in the courtroom?
Yes.
All right, I'm going to call your case then. This is cause number CR 21-0387-392, the state of Texas versus Tony McLean, and set for discovery status. State.
Everything has been handed over and an offer has been made.
Okay. And Mr. Wood?
That's correct, Judge. Everything, to my knowledge, has been turned over to us. We've reviewed it. So we can just set it for the pretrial on August 4th, Judge.
Okay. All right. And what's Miss McLean being held in Smith County on? Says a felony and misdemeanor?
Judge. Yeah, she's got about 3 or 4 cases in Smith County in the 7th District Court. She's set to actually be sentenced on those cases on Friday and be put on probation.
Okay. But she still, does she have a hold or is she on bond out of our court?
She actually has a hold out of y'all's county as well.
Okay, so she'll be,
yeah.
all right, then she should be transferred here, but if y'all could keep an eye on that in case we have to issue a bench warrant. All right, then Ms. McLean, the court deems discovery status is held. Your next court date is August the 4th at 1:30 for pretrial. And so whether you're transferred here via the Smith County or Henderson County Sheriff's Department and come from the jail, or whether you're out on bond, I need to see you in this courtroom one way or the other on August 4th at 1:30.
Yes, sir.
Okay. Anything else, Mr. Wood?
Because that's all we have. May I be excused?
Yes, sir. Thank y'all.
Thank you very much.
Thank you, Your Honor.
You're welcome. All right, Ms. Moore.
Page 7. We'll go ahead and do some of mine that may want me may
Sure.
need to do drug tests. Trey Walters.
Trey Walters. This is cause number CR 21-0094-392, the state of Texas versus Trey Walters, set for discovery status.
Discovery's been provided as well as an offer.
I've received the remainder of this discovery today. I've not had a chance to, literally when I got to court this afternoon, I haven't had a chance to review that to know whether or not I
Okay.
have actually received it. So if we could maybe carry that over to the pretrial date.
I mean, I'll set it for pretrial on August 4th, but if you need more time, just let me know then. All right, Mr. Walters, in the court deems discovery status is held. Your next court date is August the 4th at 1:30 for pretrial or additional discovery matters, but we'll just call it pretrial. And let's see. All right, I'm going to order you to take a drug test today. You'll go take the test. When you get done, come back in the courtroom. We'll go over the results together.
Jason White.
Jason White. This is cause number CR 21-0364-392, the state of Texas versus Jason White, set for discovery status.
Yes, Your Honor, everything's been handed over and an offer has been made.
We have not received an offer. I just checked on Discovery and Odyssey before I came.
What's the offer?
6-year TDC offer.
There
The
you go.
paperwork's been done. It should be too soon.
And we just got the remainder of the Discovery today with the disc this afternoon. So
I'm gonna just reset discovery status on this case and
thank you.
the TDC offer. All right, so I'm gonna just reset discovery status to August the 4th at 1:30. And so, Mr. White, stay in touch with your attorney and we'll see you on August 4th.
Thank you, sir.
Yes, sir.
Leave out the blue.
Mr. LeBlue, come on up. Who?
I didn't see him this morning. Oh, gosh. Gets ground points. No, it's fine.
All right, these are cause numbers CR 20-0387, 0388, and then 0706 and 0707. And then CR 21-0391-392, and all style the state of Texas versus Levi LeBlue. And let's see, the newer one is set for discovery status, the 0391 case.
Your Honor, these 5 cause numbers we have provided. discovery.
Okay.
That's
right.
correct.
Well, then what I'm going to do then, the others are set for pretrial, so I'm just going to set them all for pretrial so they run together. Is that all right with you, Mr. LeBlue? I'm going to do that for August the 4th at 1:30. All right. Does he have an offer to wrap all these up?
Yes, he does.
Okay.
And then I have Wendell Welch.
Wendell Welch. All right, this is cause number CR 21-0343-392, the state of Texas versus Wendell Welch, and that is set for discovery status.
Yes, Your Honor, we have turned everything over and made an offer 18 months ago.
Good.
That's correct. And Mr. Welch was benched here today.
How much time do you have in on this charge? Do you know?
I think he was in jail originally for 40 days and then
Okay.
he got a personal bond, and which brings me to he's out on a personal bond on this case. He was benched here today from Wood County with a hold on him. So I'm just wanting to make sure that we have a hold on him now so that in the event that we
Right, so
work
he's
this
getting
out
time.
later.
I don't know, if we never rescinded the bond.
So he's on your approach.
All right,
So that unless that's personal.
so he was on a personal bond, and then what happened?
I believe when he was indicted, the bond stayed, although I'm not for sure. He had a,
And then he committed a new offense, or was arrested for a new
he was
offense?
arrested in Wood County.
Well, then the court's gonna
About 2
find his
weeks
bond
ago.
insufficient and revoke his bond and set his bond at, what was the original amount?
8,500.
I'm gonna set his bond at, he's still being held in Wood County,
Yes.
right, his bond at $25,000 surety bond.
Is he gonna stay here?
I don't
Or will he
know.
be sent to Wood County? I didn't even know he was here, that they'd done a bench warrant or anything for him. Do you know?
I'm not sure, Melissa.
I mean, if he's being,
We just benched him.
so he should stay here unless Wood County benches him back.
If you're requesting for him to stay here.
Okay,
I'm
I think we-
requesting, I've found his bond insufficient, set his bond at $25,000 surety bond, and am going to request that he remain here in Henderson County. We good?
Yes.
All right. He should start getting time now.
I don't think we've set the next court date yet.
Oh, sorry, August 4th, 1:30 for pretrial, Mr. Welch.
That's all I have, just waiting for Mr. Walters.
Mr. Castleberry. Garrett Warren. He hasn't sworn yet, so you got to swear him to the faith. Still got that meth lab, what we used to call the meth lab call. Jody Miller always had it. But be careful, because it was something serious. I know I didn't know. Like, yeah, but take that non-drowsy. Yeah. But they have the non-drowsy, so it's pretty good. Mm. Oh, you gotta take, it's the stuff you can take, like if you get a mosquito bite too. What is it? Benadryl. That was amazing, but make sure you get drowsy free. We ready? Sorry, I'm just over here talking. All right, this is cause number CR 21-0327-392, the state of Texas versus Garrett Warren, set for discovery status today. However, a plea has been presented to the court. Is the state ready?
Yes, Your Honor.
And on behalf of Mr. Warren,
Defense is ready, Judge.
and before we go any further, you did get all the discovery on this.
We did,
correct?
Judge.
Okay. All right, sir, is your name Garrett Kane Warren?
Yes, Your Honor.
And are you the same person that was originally indicted by a Henderson County grand jury for the state jail felony offense of possession of a controlled substance?
Yes, Your Honor.
Get you to raise your right hand, please, sir. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Now you can lower your hand. Mr. Warren, can you read and write the English language?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
If it turns out you're not, and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, Your Honor.
And Mr. Warren, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here today?
Yes, sir.
And Mr. Castleberry, do you believe your client is competent?
I do, Your Honor.
And the court finds that he is competent. Mr. Warren, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment against you out loud here in the court?
Yes, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a state jail felony, which carries a punishment range of not less than 180 days or more than 2 years in a state jail facility and a fine up to $10,000. Do you understand the range?
Yes.
In the plea bargain?
The state is recommending 15 months probated for 3 years, a $2,500 fine, $500 attorney's fees, court costs, and $180 lab fee, as well as all standard and special terms and conditions of probation.
Is that your understanding of the plea bargain, Mr. Warren?
Yes, Your Honor.
And is that your understanding, Mr.
It
Castleberry?
is, Your Honor.
Mr. Warren, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back with Mr. Castleberry?
Yes, Your Honor.
And did you sign the front and the back?
Yes, Your Honor.
Second document, do you have any questions about it?
No, sir.
The second document I'm going to refer you to is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, Your Honor.
And did you sign that second page?
Yes, sir.
Do you have any questions about it? Do you have any questions about any of the documents that you read and went over with Mr. Castleberry? Well, if you read and went over these documents with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
Yes.
Do you want to do this plea bargain?
Yes.
And I'll ask you, sir, how do you plead to that state jail felony offense of possession of a controlled substance as alleged in the indictment? Are you guilty or not guilty? And are you pleading guilty because you are and for no other reason?
Yes, Your Honor.
I'll hear the evidence.
The state has three pieces of evidence. The first is a investigative report, the second is an inventory report, and the third is a lab report.
There's no objection, Your Honor.
All three are admitted. Mr. Castleberry,
Sorry, Your Honor.
evidence?
No, Your Honor.
Okay, close.
Let's close. Question closed.
All right, then, Mr. Warren, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that possession of a controlled substance. The court will follow the plea bargain, sentences you to 15 months in a state jail facility. However, the court will probate that, place you on community supervision for 3 years. You do have 3 days credit as to any sentence you may eventually have to serve, and orders you to pay your fine, attorney's fees, court costs, lab fee, and abide by all the regular and special terms and conditions of probation. Mr. Warren, have you ever been on probation before? Did you complete it or did you get it revoked?
I completed.
Okay, so you know what it takes.
Yes, sir.
You know what can happen to you if you violate any term or condition of this probation.
Yes, sir.
What can happen? For how long?
18 months.
That's right. If you violate even one term or condition of this community supervision, a motion could be filed, a warrant would be issued for your arrest, you'd be held with no bond, brought back before the court, and at a hearing, if the court found that you violated even one term or condition, the court could revoke your probation and sentence you up to 15 months in state jail. And do you know how state jail time is served?
Yes, sir.
Typically day for day. You understand that?
Yes, sir.
All right, and finally, sir, now that you've been convicted of this felony offense, you are now under Texas law and eligible to possess a firearm or ammunition. If you have any questions, consult an attorney. Good luck to you, sir. You need to see probation before you leave.
Yes, sir.
And Mr. Halbert.
Here it comes.
By tradition. And that's all I have. WHB.
Yes, sir. Good to see you. Ms. Riggins, you passed your test. You're free to go. Yes, sir. Sir. It says she passed her test, but she denied. Did she deny passing it? And Mr. Arnold? All right, you passed your test, sir. You're free to go. We'll see you in August. Mr. Stevens.
Page 9, Robert Anderson.
All right, these are cause numbers CR 21-0133, 34, 35, and 36-392, all styled the state of Texas versus Robert Anderson, and all set for discovery status. State.
Everything has been turned over and an offer has been made, right?
All right,
I believe we've received everything. We did see all of the initial documents are in the online discovery. We did receive an offer. So it's my understanding that all the discovery has been tendered.
all right, then, Mr. Anderson, the court deems discovery status is held. Your next court date is August the 4th at 1:30 for pretrial. And so if you get out of jail between now and then, I need to see you back here on August 5th. All right, see you then.
Then page 10, Your Honor, Gary Connor.
All right, this is cause number CR 21-0317-392, the state of Texas versus Gary Connor, set for discovery status.
Everything's been provided, Your Honor. There hasn't been any problem.
And that's my understanding. The only thing, I don't know if there's any CPS records tied to this case, but other than that, I believe we've received all the standard discovery. And if there's outstanding records, I'm sure the state will work with
I'll
me to.
check with Ms. Pace what she believes she provided.
Okay. All right, then, Mr. Connor, the court deems discovery status is held. Your next court date is pretrial on August the 4th at 1:30. And so we'll see you on August 4th at 1:30.
Pre-or bond.
That's something that has to be filed, and your attorney has to file it. The state has to have notice because we'd have to have a hearing on it.
In this type of case, I'm not prepared to make.
Right. Well, I mean, and there's not been nothing filed yet either.
And Your Honor, my other case is, believed his court was tomorrow. He's on his way. We have a plea. That's the one we talked about back in
Okay.
chambers. So he has a very good incentive to show up,
Understood.
and he's aware of his active warrant. So he's still going to be here.
All right, I'm gonna go through the docket real quick. Okay, is there anybody else ready on anything? No?
I'm gonna make an announcement on JV Nelson.
What are we gonna do? Yeah, where's Mr. Nelson? What up, Mr. Nelson? All right, these are cause numbers CR 17-0907 -392 and CR 20-0267-173, both styled the state of Texas versus Jamie Nelson, both set for competency hearings.
Your Honor, we've received the report from Terrell State Hospital finding that Mr. Nelson is now competent, and we are not objecting to that finding.
We believe him to be confident based on that.
Now, can I see the report? Before I read it, but maybe I haven't. It's still sealed up. Is it still sealed? Yeah, then I have read it. All right, well, then the court is taking judicial notice of the examination conducted by Mitchell Dunn, or Dr. Mitchell Dunn, who examined the defendant for competency. And the court notes that the physician's report indicates that Mr. Nelson is competent to stand trial to a reasonable degree of psychiatric certainty. And so based upon the court taking judicial notice of that and no objection from the state or the defendant, the court now finds Mr. Nelson is competent to stand trial. This 17 case, we need to do something with this pretty quick.
Your Honor, if I may, we've reached an agreement with the state, and I anticipate that pretty quickly we'll be able to plead all of his cases out.
My issue with that is, setting it too far out is how many times have we had a situation where Terrell State Hospital gets everybody level and restored to competency, and then they get into jail and something happens and then all of a sudden they're no longer competent. I just don't want to get into that situation.
I just mean like a week from now.
That's okay. That's what I'm saying. I don't want it too long. Well, he's competent, so let's go ahead and arraign on CR 20-0267-173. And I'll give you a few minutes to. All right, go ahead. Bless you.
Yes, Your Honor, I have gone over with the indictment with Mr. Nelson. He does understand what he's accused of, and for purposes of arraignment, we enter a plea of not guilty.
All right, then, Mr. Nelson, the court notes your plea of not guilty for purposes of arraignment. And so let's set these pretty quick.
Next time this call was here is July 14th.
A week from now. They're good with you?
Yes, sir.
July 14th, 9 o'clock, Mr. Nelson. So we'll see you a week from today.
Yes, sir.
All right. right, you can have a seat. And am I setting that for a plea?
Yes, Your Honor.
Okay, for a plea. All right, I'm going to read through the docket. If you hear your name, just let me know that you're here. DeMarcus Kaiser,
I did see Mr. Kaiser. He's not in the room, but I believe he's still in the building.
let's see. We could get Mr. Kaiser in the courtroom, please. I think we just about handled it. Manuel Garcia, you talked to Mr. Mills today?
No, sir. Judge, we talked about this yesterday. Mr. Mills is in a civil trial.
Oh, we said we would kind of get there. All right, we're gonna check and see. He's in a trial across the street. I don't know where it's at. If it looks like he's gonna be tied up for a while, I'm just gonna reset your cases. So just put this, have a seat there. Robert, oh no, yep, Robert Graham, same thing. So Mr. Mills, so we're gonna check on him, figure out what's going on. David Allison. Running late. Well, I'm gonna call it just in case. All right, these are cause number CR, or just one, CR 21-0248-392, the state of Texas versus David Allison. Is there a David Allison in the courtroom? See no one, I hear no answer. There's not a David Allison appearing via Zoom. All right, it is now 2:18. He was set for 1:30. Court will entertain a motion. Granted, a capious will issue, he'll be held with no bond, and if he shows up, we'll take it up. Mr. Kaiser? Well, DeMarcus Kaiser. Is DeMarcus Kaiser in the courtroom? See no one, I hear no answer. Let me call him. CR 20-0576, CR 21-0324, and 0325-392, all style, the state of Texas versus DeMarcus Kaiser. DeMarcus Kaiser is not in the courtroom. He's not appearing via Zoom. No answer in the lobby. The court will entertain a motion. Granted, a capious issue, he'll be held with no bond. However, if he does come back, then I'll reconsider.
And I do believe
He's got a warrant out of the county court law, so I need him to be in the jury box, but I hear he's trying to take care of that.
and that's my understanding. Would you like for me to just stick around and see? Oh, that was the last case I had.
It's up to you. I don't know whether he's going to show up or not.
I'll give it a little bit.
I mean, because we're going to have this, a status on him. So yeah, if you don't mind.
Yes, sir.
Ms. Thompson. Yes, ma'am.
Honorable Matthew Pocas, he has requested I speak to you in chambers about an issue. If the court would allow me to have a few moments of your time.
I don't oppose if you.
Well, I'm not going to do it ex parte.
Well, I explained to him he was wanting it directly with you, and I said, no, that won't happen.
Oh, he wants to do it, not you.
Well, that's what.
No,
he
I'm
wanted
not. I mean, that'd
first.
be inappropriate for me to talk with the
I
defendant.
understand that. Explained it to him, and I said, I might talk to him, but you can't.
Yeah, I don't want the defendant.
No, I understand that. I understand that. So,
Anything else ready?
okay, thank you.
All right, let's take a quick recess. Y'all let me know, and I'll see y'all in chambers. I'll see you on chambers, but real quick on so I don't forget when we come back. Mr. Mills, it appears, is going to be probably the rest of the day. Mr. Garcia, I'm resetting your cases. Just want to do August 4th. You're the one just like you're going on a safari.
Mr. Mills will be here tomorrow morning.
Mr. Garcia, if I have you come back tomorrow morning, is it going to keep you from working a job?
I can come in tomorrow.
Okay, so tomorrow morning, 9 o'clock. So if we can get Mr. Garcia a reset notice for tomorrow morning at 9 a.m. And then the same thing with Mr. Graham. Mr. Graham, you got anything going tomorrow? You think you can make time to come over at 9 o'clock? All right, then we'll see you tomorrow at 9 a.m. as well. You never know. I mean, you could have a doctor's appointment. All right, and then so, Ms. Moore?
I think we have Mr. Walters breakfast as well.
Mr. Walters, you're free to go.
That's all I have.
Yes, ma'am. And who's Mr. McCleskey, his attorney?
We have McCluskey's drug results as well.
Who is his attorney?
Mr. Harris.
Well, I might as well get those done. Ann's probably back there wondering what happened. All right, let's go back on the record and cause number CR 21-0328-392, the state of Texas versus Terry McCleskey. May I see the docket sheet? Mr. McCleskey, based upon the nature of his charge, is ordered to take a drug test. It appears as though he has tested positive for methamphetamine and amphetamine. Mr. McCleskey had previously tested positive on May the 6th of 2021. So he's on conditions of bond. The court's going to find his bond insufficient. What is it at right now?
Judge, on this case, he adamantly denies any use. He has presented a Risperdal.
Well, also, my understanding, he supposed to show a photograph on his phone for Risperdal, but Risperdal shouldn't test positive for methamphetamine. It's only
Yeah, there's some literature that supports, but maybe.
He has a prescription for it.
They didn't have a date for it. They said sort of provide a date.
All right, I'm going to send it off for, I'll give you the benefit of the doubt. I'm going to send it off for confirmation and see you back on August 4th and we'll have that back. Did you save it?
Yes.
Okay, yeah, let's send it off for confirmation.
Thank you, Judge.
Because if it's going to test positive for amphetamines, I'll give them the benefit of the doubt right now.
Yes, sir. Thank you, Judge.
And you also need on August 4th to bring that prescription in as well. Not a phone, not a photograph.
I have two phone numbers. Yeah, I forgot to bring this other one in.
All right, fair enough. All righty, we'll see you in August.
Thank you, Judge. Maybe it's you.
Yes, sir. Anything else? All right, I'm going to take the recess now. I think Ann's probably wondering what happened to us. So- Oh, there you are right there. Okay, I thought you were waiting back there.
Yes,
Well, you wanted to talk to me.
yes, sir.
Oh, okay.
I thought you refused it. I thought you refused it, Your Honor.
No.
Misunderstood.
I said I wasn't going to do it ex parte.
Oh, no, no.
Please.
Yes. The signature, I need to redo it. 'cause the signature-
Did I just do that? Both of these are styled, the state of Texas versus Matthew Poe. The court earlier held discovery status, and Mr. Poe was later ordered to take a drug test, and he has taken that test. It appears as though he has tested positive for methamphetamine and amphetamine. Also, in looking at the docket sheet, it appears as though this court back in May, on May the 6th, via Zoom, ordered Mr. Poe to submit to a drug test. On May the 11th, he showed up to probation, yet did fail to submit. And attempted to submit urine other than that at the drug test. So what I'm going to do is the state, I want to call the probation officer, is the state calling anybody? I
Yeah,
guess.
we have two witnesses, Your Honor. If we
Okay.
make a call, bring this in.
Okay. All right. And she's an officer of the court. Does anyone mind if I waive the oath?
I'm okay, yeah.
All right.
Maybe just, and then,
Yes, sir.
You could state your name for the record.
Brenda Skinner
How are you presently employed?
through Henderson County CSCD Adult Probation
How long have you been employed in that capacity?
for 14 years.
So you would have been employed in that capacity in May of this year.
That's
Were you on duty on May 11th, 2020?
I was
And what were your hours that day?
from 8 to 5.
Were you aware of any orders in this case on Mr. Pope?
I became aware of it whenever his wife called and said that he was at work and wouldn't be able to make it in to do it.
Do you remember about what time that phone call came in?
I believe it was around, I really don't know.
Did the defendant, were you aware of him arriving for a drug test that morning? On May 11th?
I believe that he showed up in the afternoon.
So he didn't show up at 9 o'clock. as far as-
No, he did not.
And 10 o'clock,
No.
11.
I don't think so, no.
I'll pass it on.
Ms. Skinner, do you recall that when the wife called, whether it was morning or afternoon that she called?
It was morning.
No further questions, Your Honor.
And you said that she said that he was working.
That's correct.
Pass it on.
Anything else, Ms. Thompson?
No, that's Brenda's claim.
Next witness?
Oh.
Colin Laurie.
Right, same thing. Does anyone mind if I waive the oath since he's an officer of the court?
No, I do not, Your Honor.
All right, go ahead.
Could state your name for the record.
My name is Tony Larry.
And how are you presently employed?
I'm employed as a probation officer for this county. Community correction board.
How long have you been employed in that capacity?
18 years. I've been a probation officer a total of 23 years.
So you would have been employed in that capacity in May of this year.
Yes.
What are some of your duties as an officer?
Some of the officer is to sometimes administer drug tests, see the officer court, for grand juries. Make sure they abide by conditions placed on probation.
And you said drug tests. About how many drug tests do you administer?
In my lifetime?
Many or few?
Many.
And I'll just leave it at many. And were you on duty on May 11th?
Yes.
And what were your hours that day?
I believe that they are probably working from like 8:30 to 5.
Were you aware of any court orders or issues or directives issued by this court on Mr. Pope's case?
I think I remember he might have ordered the drug test via Zoom on a particular day.
Okay.
But Ms. Skinner asked me to perform a drug test when the defendant arrived.
Okay.
And I believe we're supposed to be in that morning. I think it might have been 9 o'clock in the morning, if I remember correctly, based on order from the court. But I'm not accurate assessment. I can just tell you the time he showed up around 2:58.
Okay, so not in the morning.
No.
He wasn't like sitting for 6 hours waiting on the drug test?
No.
So when you wrote down that time, about how long do you think he'd been waiting?
I went back to conduct the UA of around, I think, probably about 3:10 or so. Probably back to the UA.
Okay. So when you call him back there, how did that happen?
So basically, they in the front lobby. I go out to the front lobby, ask the defendant to come back into the bathroom area. And the normal standard, when I do drug tests, I ask them to place the shirt up and turn around front and backwards. Just so I wanted to take the seat and have any devices. A lot of times, most people have devices that strap around the waist or on the side, something of that nature. And at the time, I didn't have anything to show. And then from there, he proceeded to pull his penis out, which I was at that time observed before. So in the bathroom, our bathroom, we have a mirror place right here. A lot of times you can look down from the mirror and watch the person urinating in the cup.
And just for the record, you're saying there's a mirror in front of the person?
It's a mirror, okay, like this is the bathroom here. And in the corner, we have a mirror that looks down. We have 2 bathrooms. We have a urinal to the left, and then we have just a regular toilet to the right.
And this allows you to see
This allows me
the front of them.
Yes. So at that time, we proceeded to start, Graham started submitting to UA as he pulled his penis out. He had the cup initially there, and all of a sudden it seemed as though that he had extra movements to where I couldn't tell if he was going to urinate in the cup or if he was going to use a device. So at that time, I told him to stop the UA, asked him to turn around and to go ahead and expose his pants to make sure he had no additional device. And at this time, he basically kind of refused to open his pants. So I came around, I observed his penis, and he had like a lump part on his penis where I questioned like to what was that, to see if it was maybe a device or if it's his. And he explained to me what it was, and he said it was a domino that was inserted inside.
I'm sorry, it was a what?
A domino that's been inserted into his penis. And from there I said, okay, can you still go ahead and open your pants up so I can observe and make sure you don't have anything? And the only thing he proceeded to do was he never would open his pants up. He proceeded to pull his penis out with his testicles and lift up. And I said, that's still not suffice. At this time, he became a little more argumentative and eventually proceeded on. He accused his officer of sexual harassment. While we was arguing between the time, I said, do I need to ask for Christy, do I need to get a deputy to proceed to assist me with the drug test? And as he stepped out the bathroom, he didn't come back. And by the time I got to get a deputy, he had already left.
What is the domino, just for the record?
I know what one is, but for the record.
My understanding, I think a domino is you take a piece of domino and you insert it on, you put it in the penis, and you insert it in the penis. And once it heals over, it can be used for, I guess, sexual pleasure on a later date.
So that's not like a drug device?
No, it's not.
In your experience, have people used drug devices or urine devices?
Yes.
What would be the purpose of something like that?
To pass a drug test.
So like a false bladder or something like that?
Sometimes people use false penises, sometimes people use blue bottles, or any other device that's going to be considerable to where they can use maybe someone else's urine to pass a drug test.
And that's happened to you in your experience?
Yes, on several occasions.
And that you believe in this case that happened?
In this case, I do believe it happened. Because I was not able to get a good sample because he left before.
So you did not submit that sample that is
No.
in your possession? No. But you didn't think it was about?
That's correct. And it just on like it wasn't enough of a sample for me to get because once I asked him to stop, I didn't get any additional yes.
And you recognize that person in court today?
Yes.
You could identify him.
Matthew Police standing to my right and with plaid shirt, blue jeans, and boots.
And record reflections of the findings.
Yes, sir.
And that happened here in Anderson County?
Yes.
At the probation department in this courthouse?
That is correct.
Ms. Thompson.
Mr. Larry, you never, make it clear to the record, you never saw any kind of device on him to be used to deliver urine in a cup. Is that correct?
And that would be correct because I didn't get full exposure.
Okay, just answer the question. So the only thing you saw on him that was considered not correct or abnormal would be the domino. Is that right?
That is correct.
And that's not a device for giving out urine. Is that correct?
That is correct.
All right. And at the time that you asked him to uncover himself so that you could view more appropriately, he expressed to you that he was uncomfortable with that. Is that correct?
Not initially.
Okay.
Only
Did
thing-
he at any time during the interview tell you that he was not comfortable doing that?
Yes, towards the end of the interview, yes.
And he felt like it was for sexual harassment. Is that correct?
Yes, he did accuse me of sexual harassment.
You had the opportunity to stop it and call for the deputy to come. Is that correct?
I did go call for the deputy, but he proceeded to leave when I went to get to the deputy.
Okay, just answer the question, please.
Answer the question.
No, you're going more.
Okay, hold on. What was the question?
Question was, did he go call for a deputy?
I said, yes.
Okay, and nothing further, just answer what I asked. he did show for the point, not at their appointed time, but he did show, did he not?
Yes,
Okay. Did he come with urine? I'm not sure that I understand that. Did he come with some urine?
I can't answer that question because he never revealed it to me to know for sure if he did or did not.
But when he did expose himself, you did see his penis and you did see his testicles, is that correct?
I did see that. I just couldn't see what was underneath.
Did you ask him to hold his testicles up?
No, I said, open your pants.
Okay.
And he never opened his pants. That means fully open your pants. And pull down your pants to see if there's anything inside that can fall out. Because most cases, that's what happens. You can hold your pants and hold it and conceal.
I understand, I understand. I don't have any further questions, Jim.
Mr. Larry, you have to look at the penis when you're doing this drug test for men.
Yes.
Is there anything sexual in nature about that?
No.
Did you seek any sexual gratification in doing that?
Oh, no.
And you had to do this as part of your job,
Yes.
and you've had to do this on many occasions.
Yes.
And in this particular case, did you feel like the sample that was produced was valid?
No.
And why is that?
Because I actually didn't see it stream from his penis into the cup. And he had additional movements more than normal when I observed someone submit a sample to the cup. And normally for just for verification purposes, when we have a situation where we're not completely sure what a person, if they have a device, we request that they open their pants and pull down their pants just to verify that they don't have any other devices on them at the time. And that's all I was simply requesting.
You asked that in this case?
Yes.
Was that compliant?
No, that was not compliant.
I'll pass it on.
No further questions, Your Honor.
Nothing further.
Anything else? Good. Any other witnesses?
No other witnesses, Your Honor.
Ms. Thompson, do you have any witnesses?
I would call my client, Your Honor, for the limited purpose of testimony here today.
And Your Honor, before she does that, just to finish my case, I'd ask the court to take judicial notice of your request on May 6th of this year.
The court takes judicial notice of it. And Ms. Thompson, so you're calling the client?
Yes, sir.
Right, and again, this is for the limited purpose, sir, of just this hearing. And so if you could raise your right hand. And you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Ms. Thompson.
Mr. Poe, you understood that you needed to show up on May the 11th for a urine test, is that correct?
Yes, ma'am.
And you did show up for the urine test.
Yes, ma'am.
You were late, is that correct?
Yes, ma'am.
But you did show up for it.
Yes, ma'am.
Okay. When you were asked to give the urine sample, did you feel comfortable during that examination?
No, ma'am.
Okay. Would you explain to court briefly in your own words what took place that made you feel uncomfortable?
I told him to pray. When I walked up to the toilet, I told him he was standing right behind me, and it makes me uncomfortable because of something that's happened in the past. And then I told him, I said, making me feel uncomfortable. And he said,
I'm sorry, you're going to speak
He
up.
told me to go ahead and do my business, use the bathroom or admit a sample. And it just made me uncomfortable. I don't know, like, I don't know what I'm talking about. I turned, I guess, or whatever movement he said I was trying to do. I just I said I feel uncomfortable. And I started being the cup, and then he I got looked. So I showed him.
Did he ask you to expose yourself?
Yeah.
And that's what made you feel uncomfortable, is that correct?
That's me.
No further questions, John.
Mr. Poe, do you know what time you were supposed to take your drug test that day?
I know it was supposed to be that day.
Do you remember that there was a Zoom hearing on May 6th?
Yes, sir.
Would it shock you if I told you the judge said to come at 9 a.m. in the morning?
That's that part. All I understood was come in that day and take a UA.
Approach the witness, Your Honor.
Yes, sir.
This was from Zoom.
Yeah. Don't you-
Anything else I'm showing? Transfer from court to defendant. Is that something? Your Honor, I approached the witness with the transcript from the Zoom hearing. It's out loud to the court.
I can't hear him either.
And then what else do you need to do? Defended, Tuesday morning, I need to go to the probation office and take a drug test.
So is it fair to say that the judge told me to go in the morning?
Yes, sir.
Do you believe that you show up in the morning? What time do you think you show up?
Right. I was sick that day whenever I had the Zoom conference. I was sick.
Have you been drug tested before?
Yes, sir.
Do you understand that it's, by its nature, it's kind of a situation that exposes you?
Not what asked tonight.
But you've been drug tested before in the past.
So on there was my probation officer before.
I'm sorry, I didn't hear that.
Speak up a little bit, I can't.
Yes.
No, what did he say before that?
Told them there used to be my probation officer.
Your testimony today is that you felt uncomfortable. Did anything happen to you? In this case, not in the past, but in this case, did anything inappropriate happen to you? Is that what you're saying?
Kept asking me to pull my pants down, and it's
You feel that was inappropriate?
looking at another man's genitals, yes.
Okay.
The way I was raised, yeah.
Did you file a complaint with his supervisor?
Not supervisor, no less. County clerk.
So you filed a case against him?
I called to see how I could report it and approach it.
I'll pass it on.
Anything else?
Mr. Poe, did you wind up leaving that day?
Yes, ma'am.
But you had started to give him a urine specimen, is that correct?
Yes, ma'am.
And you were stopped, is that also correct?
Yes, ma'am.
Nothing further, Your Honor.
Anything else? Any other witnesses? Ms. Thompson?
No, Your Honor, no further witnesses.
Okay. Do y'all want to argue
I can make a closing, Your Honor.
briefly?
We asked the defendant today to show cause. I don't think he showed a good cause. He didn't have an emergency situation that morning.
Well, but I am not considering this
No.
a motion or show cause. This is a bond hearing.
And I'm gonna go on with that.
Okay.
I do believe he was in contempt and hasn't shown cause, but under 1744 of the Code of Criminal Procedure, this felony court can, as a condition of bond, have a defendant take a drug test. In that case, he didn't appropriately do it per probation as requested by the officer. Even if he did produce something, because he didn't follow the guidelines, it wasn't considered valid. For that reason, he could submit it. Mr. Wright testified to that. that the way it was conducted wasn't conducted properly, and that was because of the offense. So we'd ask that you find the bond insufficient for violating 1744 of your condition of bond that would require him to take a drug test. And additionally, today he's also failed a drug test.
Thank you, sir. Ms. Thompson?
Your Honor, we're not arguing a show cause for contempt, but I think it is important for the motion that was filed by the state to say that the instructions given to Mr. Poe on the May the 6th were clear, but when he was asked to repeat those instructions, he did not give the appropriate or correct response to the order that was given, and the court did not correct him as to what time he needed to be there. He did say that he needed to be there that morning, but he didn't specifically say 9 o'clock as the court had ordered. So I don't think it was clear to him, the instruction should have been corrected at that time.
So you're saying the court, when the court says, Mr. Poe, I need you to report on such and such a date at 9 a.m. for a drug test. And then one of the 13 principles of leadership is administrative control and knowing that somebody understood what you just said. So I asked him, what are you supposed to do? I'm supposed to report Tuesday morning. So I should have corrected him and said, no, Mr. Poe, you should have reported Tuesday. You are reporting Tuesday morning at 9 a.m. So that's your argument?
Yeah, Your Honor, I
Okay.
think that's the argument. And this, another argument is that he did show up late, but he did show up for the urinalysis. He has testified that he felt uncomfortable, but he did give a urine specimen and was stopped from completing that urine specimen. So, and then he left. So we would argue that he didn't get proper notice. He didn't get clear written orders as to what he had to do. And that he did show up for urinalysis, that he did attempt to give a urinalysis.
Thank you, ma'am. All right, well then, first of all, the court finds that Mr. Poe's bond's insufficient. I understand the testimony, but I mean, if he was making furtive movements and then he finds out that he has a domino inserted in his penis, of course, that would cause any reasonable person to question what else is going on. And based upon his many years' experience of having people that are attempting to falsify their urinalysis, I think that what his actions were, from the testimony, I believe his actions were reasonable. And so that, in addition to the fact that Mr. Poe, this would be his second, I believe, this is second or his first, I can't see the dockets.
I think that he's had 2 prior convictions or
Well,
still about drug
convictions.
tests.
Right, with the prior failed drug test, and the court finds his bond insufficient on each case. And what are the bonds on those cases?
Personal bond on Sierra 21. Sierra 21, 356, 392. Looks like a 1500.
Right, so each bond will be set at 15,000 surety with conditions. Mr. Poe, you still have the same conditions. If you bond out, as you know, you come back to court, I'm gonna drug test you again.
Apologize.
It's okay.
I didn't. All I thought was show up, take you away that day.
But you are positive today. And so if you do bond out and you have a drug problem, I'd rather you be in treatment. And if you need help, there's lots of help out there. I'd encourage you to get it.
I started a new job and I'm working, slipped up with July.
Okay, well, don't,
When
no, I don't want you to say anymore because the prosecutors are here and they're listening to everything you say, and for your own good, I'm just going to ask that you don't say anymore. And again, if you are out of jail between now and August 4th, I need to see you back on August 4th at 1:30, sir.
Thank you.
And we just have one more left. Did Mr. Kaiser ever show up? Did he ever find his way back to the courtroom?
Not to my knowledge, I don't know if I'm available to log in.
No, I've already forfeited his bond.
Did you want me to keep hanging out?
Oh, no, I'm sorry. I was just thought you were seeing if he would show up. You don't have to.
Okay.
Okay.
Well, thank you.
You're welcome.
I'll see you in the morning. bargain.
And David Allison for plea, Your Honor, page 8.
Mr. Allison, come on up. Oh, that's right. And I'm on to, first of all, let me call it CR 21-0248-392, the state of Texas versus David Allison. Mr. Allison, court was at 1:30 today, and it is now 3:42. I don't know what time you got here, but it's probably to your benefit that I had to wait for Mr. Poe to use the restroom. So I'm going to recall the bond forfeiture. Also, on the reset notice that you received, I think, is there still a dress code on there? And can I see one of those? You will not be allowed to enter the courtroom if you are wearing any of the following: shorts or pajamas. But your attorney told me you came from work, and you know what? At least you're working, so that's.
Yes, Your Honor. I drove here, well, my uncle drove here from Arlington.
That's okay. And so is this on this case or another?
Yeah, you didn't show
That's on this case.
You didn't show up last time, so we have a bond for warrant out.
And y'all have an agreement that he's going to plead and we're going to get rid of this?
Yeah, we're gonna not suit the.
Okay. All right. And so a plea has been presented to the court. Is the state ready?
State's ready, Your Honor.
And on behalf of Mr. Allison,
We're ready, Your Honor.
all right, sir, is your name David Joseph Allison?
Yes, Your Honor.
And are you the same person that was originally indicted by Henderson County Grand Jury for the second-degree felony offense of possession of a controlled substance?
Yes, Your Honor.
And get you to raise your right hand the best you can, sir. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
And lower your hand. Mr. Allison, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And I have to ask that question of everybody. Mr. Allison, have you ever been treated for any mental health or emotional issues?
No.
You understand what's going on in here?
Yes, sir.
And Mr. Stevens, do you believe your client is competent?
I do, Your Honor.
The court finds he is competent. Mr. Allison, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment against you out loud here in the
No,
court?
Your Honor.
You gotta let me finish the question. That a no. All right. Well, as indicted, that charge is a second-degree felony, which carries a punishment range of not less than 2 years, nor more than 20 years in the Texas Department of Criminal Justice, and a fine up to $10,000. Do you understand that range of punishment?
Yes, Your Honor.
However, it's my understanding that you have this agreement worked out with the state whereby they would reduce this to the lesser included of that which is charged to a state jail felony, which carries a punishment range of not less than 180 days or more than 2 years in a state jail facility and a fine up to $10,000. Do you understand that punishment range?
Yes, Your Honor.
And further, they are recommended to the court in exchange for your guilty plea that the court convict you and punish you as a Class A misdemeanor under 1244B of our penal code. The punishment range for a Class A misdemeanor is up to 1 year in the county jail and a fine up to $4,000. Do you understand all those punishment ranges?
Yes, Your Honor.
And the plea bargain?
Thank you, Judge. The agreement is for 37 days county jail under that 1244 beyond the lesser, with credit for 37 days plus court cost attorney's fees and $180 in restitution to the lab. The state will ask this court to take into consideration unfiled bail jumping with felony, and will seek a non-suit on the civil side of that.
Is that your understanding of the plea bargain, Mr. Allison?
Yes, Your Honor.
Is that your understanding, Mr. Stevens?
Yes, sir.
Allison, a few minutes ago, you told me you could read and write the English language. 2 documents I'm going to go over with you. The first is the agreed plea recommendation. Did you read and go over that with Mr. Stevens?
Yes, I did.
Both the front and the back?
Yes, Your Honor.
And did you sign the front and the back?
Yes, Your Honor.
Do you have any questions about it?
No, Your Honor.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, Your Honor.
And did you sign that second
Yes, Your Honor.
or second page? Sorry. Do you have any questions about it?
No, Your Honor.
you have any questions about any of the documents that you read and went over with Mr. Stevens? Well, if you read and went over these with him, I know that he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No.
Do you want to do this plea bargain?
Yes.
And I'll ask you, sir, how do you plead to that lesser included offense, that possession of a controlled substance under 1244B of our penal code, a misdemeanor? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, Your Honor.
I hear the evidence.
State offer states 1, states 2, and states 3, and the evidence states 1 is the offense report. States 2 is Morton discovery compliance, and states 3 is
No objection.
Admitted.
nothing further from the state rest and close.
Rest and close as well, Your Honor.
All right, Mr. Allison, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that lesser included offense under 1244B of our penal code. The court in sentencing you considers this bail jumping from June 1st. Court will follow the plea bargain, reluctantly follows the plea bargain, sentences you to 37 days in Henderson County Jail with credit for 37, and orders you to pay your attorney's fees, court costs, and lab fee. And I just got to be honest with you, Mr. Allison, we're post-COVID. Had this happened any other time, I probably wouldn't have accepted this plea bargain. And the attorneys told me about some other things in chambers in a bench conference that we had, or a chambers conference. And so a couple more questions for you, or just one actually. Did you have an opportunity to review the judgment in your case?
Yes, Your Honor.
Was your name, the charge, and the time credit correct?
Yes, Your Honor.
All right, sir. You need to see Mr. Halbert. Sorry, I'm giving you all of it on a slate. You need to see Mr. Halbert to be credited, and good luck to you.
There you go. That's all. The court may be excused.
Yes. Is that it?
That's it. for
Good
me.
luck. So you're gonna go dump all that salt in your pool?
Go dump it. So I need to watch another YouTube video because it says run the circulation, but I'm afraid if I dump it too close to the drain, it's just gonna suck
know what
it
I
in
do
and
in-
clog my filter up.
You know what I do to mine? Do you have a tanning deck?
Mhm.
I pour it on the tanning deck, and then do you have the bubblers on it? And the bubblers just kind of
Get it all
dissolve.
worked up.
That's what my pool guy told me to do. so
Okay.
That's what I pour mine.
That's fine.
Yep. Then you don't have to worry about it getting in your.
Yeah, because I just cleaned the filter yesterday.
Judge, these are two of my students. May they approach?
Sure.
This is, oh my gosh. and she's
I
in
know, I mean,
shorts.
Did you not just hear what I just read?
I said, shorts.
No, you're okay.
And
So
her
y'all are,
husband's a game warden.
who's your husband?
Greg Johnson.
Yeah, game one.
Woody Allen.
We won't talk bad
Woody-
about
well, not
it.
Woody Allen, gosh. no. Woody Allen.
Well, it's very nice to meet y'all.
Julia, nice to meet you.
Nice to meet you.
Hi.
Nice to meet you.
Nice to meet you.
This is my intern.
Hi. Yeah, you were great.